and paragraph 166 about the report of the 21st of August 2014, you say the report contains many points that were damning. Whether at the time I saw it, I recognised quite how damning they were, is less clear in my mind. There's no reference, for example, to the Post Office or Fujitsu being able to access Horizon remotely, something I remember being concerned about. But the question, quote, is Horizon fit for purpose, is answered by Second Sight's conclusion, no. Uppermost in my own mind was always the question, have the actions taken against these sub-postmasters, whether disciplinary, litigious or prosecutory, been fair, and are the results safe? The conclusion I would have drawn from the summary whenever I did see it was almost certainly not, and certainly not in every case. Can we look, please, at the report itself? Poll 303-0160. This is the report that you're talking about, the Part 2 Second Sight report. And I'm not going to go through it all. It's over 20 pages in length and it speaks for itself. Can I just look at one part, please? Page 22. Reading from the bottom, paragraph 22.1. Yes, that's it, thank you. The report deals with things under headings or themes, and there are headings of training, of contract issues, and this is dealing here with Post Office investigations. And Second Sight say, and to be clear, this is a report that goes to the Post Office, including to Paula Venables and the then chair of the Post Office, Alice Perkins. As a result of our investigations, we've established that Post Office's investigation team has in many cases failed to identify the underlying root cause of shortfalls prior to initiating civil recovery or criminal proceedings. This includes cases where applicants brought to the auditor's or investigator's attention their own suspicions as to the underlying root causes. Is that one of the paragraphs that you had in mind when you said that you would have drawn the conclusion, have the actions been taken against sub-postmasters, including litigious or prosecutorial, safe?
Yes, certainly it is.
Many applicants, it continues, and almost all the professional advisors assert there was inadequate investigation prior to suspension without pay, termination, or civil criminal action. Based on the cases examined so far, Post Office's investigators seem to have defaulted to seeking evidence that would support a charge of false accounting, rather than carrying out an investigation into the root cause of any suspected problems. Evidence to support a charge of false accounting is often easily obtained, since when confronted during interview with evidence of obviously overstated cash figures, the accused person will often readily admit to falsifying the end of trading period accounts. And over the page. With the exception of an interview conducted in accordance with PACE, we note that the interviewee is not allowed to be legally represented, although they may be accompanied by a friend, albeit with very limited powers. Interviews will usually be recorded, and when an admission has been made, this will virtually always trigger a guilty plea by the defendant, and often an associated repayment proposal. As a result, Post Office investigators seem to have found that recording admissions of false accounting was the key to achieving relatively rapid, and to the Post Office, inexpensive asset recovery. As a consequence of this, Post Office's investigators seem to have de-emphasised the importance of unearthing the true root cause of the mysterious shortfalls that applicants claim to have suffered. Even when faced with requests from sub-postmasters for investigative help, this has often been refused. Regrettably, this refusal to provide investigative support is in line with the standard contract. It's clear from comments made by applicants this is clearly contrary to their expectations, and that they were unaware that under part of the contract, the Post Office Investigation Division does not have a mandate to provide general investigative support to sub-postmasters. Post Office's instructions to and training of its investigators seems to have disregarded the possibility that the Horizon system could be in any way relevant to their investigations. A consequence of this flawed approach to investigations is that many opportunities for process improvements have been missed. And then last page. So I think that is the last page. Thank you very much. Is that included in your description of the report containing many conclusions that were damning?
Yes, it was an asset recovery process rather than an application for justice.
You tell us in your witness statement that by this time you'd come to trust Ron Warmington and Ian Henderson.
Yes.
Your feeling about their approach was that they were straightforward, open, competent and experienced in the issues with which you were all dealing.
Yes.
You had by this stage abandoned your initial suspicion of at least Ron Warmington's past friendship with Susan Crichton.
Precisely.
And you say in your witness statement, at the same time the Post Office personnel with whom I was dealing had become defensive, legalistic and determined to keep from MPs information about which they had previously promised to be open. Where there was a dispute between Second Sight and the Post Office, I felt more inclined to favour Second Sight's version.
Yes.
Sorry, that can come down, thank you. Where you say that the Post Office personnel with whom you were dealing had become defensive, legalistic and determined to keep from MPs information, who are you referring to there?
Well, particularly Paula Vanel's. I can't remember precisely which meetings I had with Chris Ojard and Angela van den Bogart, but those were the people with whom I dealt with most. Alice Perkins to a certain extent as well.
Can we go to page 92 of your witness statement, please? Paragraph 170. Page 92, paragraph 170, and you, I'm not going to go to the letter because you summarise it here, that on the 5th of September 2014, Angela van den Bogart wrote to Second Sight, asking Second Sight to reconsider their recommendation that a particular case was suitable for mediation. The reason she gave boiled down to the fact the applicant had pleaded guilty in court for false accounting and theft, so there was no basis left for mediation. Then skipping on in the same paragraph, you say, if the same logic were applied to all of the cases where there had been guilty pleas, then the basis of the mediation scheme would have been fundamentally changed. Was this one of the aspects which led ultimately to the breakdown of the mediation scheme?
Yes.
Paragraph 171. You tell us it had always been obvious that the mediation scheme wouldn't have been able to alter convictions in court. In the question you'd asked in Parliament, if we go over the page, you said we must look after them and try and provide them with redress, perhaps through the CCRC.
Yes.
Is it right, therefore, that you saw the mediation scheme not as a means of overturning or even questioning by the words used by Second Sight convictions themselves, but providing an investigatory platform and uncovering material that might itself lead to a reference to the CCRC?
Quite. It would give rise to further processes overturning miscarriages of justice.
Thank you. You deal in your witness statement, again supported by the contemporaneous material, with the Post Office's response to Second Sight's second report. Can I just pick out some key passages, if I may? Paragraph 178 on page 95. the long and the short of it is summarised in paragraph 178. Post Office replied to the second report and said it was unable to endorse it.
Yes.
What did you think when the Post Office said that it was unable to endorse the report?
By this stage, I wasn't surprised because of the Post Office's defensiveness, secrecy, legalism, and the fact that it seemed to be blocking information to go to second sight. And the Part 2 report was not kind to the Post Office, and the Post Office was going to get even more defensive when it came out.
You tell us in the second part of paragraph 179, which is on the screen there, that when you saw the reply, you assumed from its tone that it had been drafted mainly by Chris Oyard, as it struck you as unconvincing, defensive, offhand, and designed to be obstructive.
Yes.
Why did you associate this reply with Mr. Oyard?
Because I considered him to be unconvincing, defensive, offhand, and obstructive.
This all culminated in a meeting in your office at Portcullis House on the 17th of November 2014. We can see that from paragraph 198 on page 103. You referred earlier today into a meeting in which I think you said the MPs let rip or some similar expression. Was this the meeting you were referring to?
It is.
Were there strongly expressed views by MPs at that meeting?
Very strongly expressed views.
To what effect?
To the effect that the MPs essentially broke off relations with the Post Office and said that the Post Office's behaviour had been such that we couldn't trust the Post Office anymore, and that we weren't prepared to take further part in the mediation scheme or negotiations with the Post Office.
We can see from 199, if we go over the page, please, your memory of the meeting, and you say you felt it was controlled on the Post Office side by Angela Vanden Bogard and Chris Oyard. They said the Post Office should exclude altogether from the mediation scheme people who pleaded guilty. A different proposition from an earlier one that had been made of being put to the back of the queue. And you asked them how they thought you would have supported a scheme which excluded my constituent, Joe Hamilton, to which they had no answer. And for you, that was the final straw. And you say Paul Avenel seemed almost cowed by their stronger personalities and said little. I told her she was breaking her word. I sensed, rightly or wrongly, that she felt ashamed, and the meeting broke up in acrimony. Does that accurately reflect what happened?
It does, yes.
Why did you think Angela Vanden Bogard and Chris Oyard were seeking to resile on the promises, as you saw it, that had previously been given by Paula Venables about which issues could be investigated and access to which documents would be given?
I thought at the time that they were worried that Second Sight was actually uncovering something really crucial about Horizon, that they were worried that Second Sight was getting too close to the truth, and that if they allowed Second Sight to go on uncovering these things, it posed an existential threat to the future of Horizon, and that in turn posed an existential threat to the future of the Post Office. That's what I thought they were doing, and I still think that that's what they were doing.
And so it was the conclusions that had been reached in this second sight report that, in your view, were fundamental to a sea change or a step change in the Post Office's position?
Yes, although they'd begun before the second part of the second sight report came out.
In paragraph 201 of your statement, which is on at page 106, you say that shortly after that meeting, Paula Venables wrote to you rejecting a proposition that there should be a presumption in favour of second sight's recommendation as to who should go forward for mediation.
Yes.
I think what you've been suggesting is that if second sight suggested that an individual case should go forward to mediation, then that case should presumptively go forward to mediation.
Yes, well, MPs, when we'd gone in for the mediation scheme in the first place, had expected that every case would go forward to mediation except for one or two outliers that might obviously have been a sub-postmaster trying it on.
Did you see anything controversial in a proposition that if an independent investigator recommended that a case should go to mediation, then the case should go to mediation?
Nothing controversial, not least since the independent investigator had been appointed and recommended by the Post Office itself.
Can we look at the Paula Venables letter to you, poll 00101699? And this is her letter to you of the 28th of November 2014. She says, thank you for meeting in your office on the 17th of November. I'm setting out the Post Office's position on the proposition put forward that there should be a general presumption that the Post Office will agree, save in a few undefined exceptional cases, to mediate all cases where this is the recommendation of second sight, regardless of their merits and specific circumstances. Having considered the proposition carefully and having discussed it as promised with my board, I've concluded I cannot agree to it. You tell us in your witness statement that this gave you a sleepless night or sleepless nights. Is that right?
Well, this is what it seems I told Alice Perkins, yes. But I think the sleepless night came from the breakdown of the whole process.
And so it wasn't specifically the rejection of this proposal. It was more that you could see that the writing was very clearly on the wall.
Yes.
Can we look at your reply then, please? Poll 00101700. This is your reply to Paula Venables of the 8th of December 2014. It's a long and detailed letter. I only want to look at the conclusions, if I may, on page 3.
Yes, I'm sorry it's so long.
And if we scroll down, please. Under conclusions from paragraph 13 onwards, you begin a series of paragraphs in the same way, despite something. Despite the fact that Second Sight have identified the issues of investigations and contract giving rise to concern, ... the Post Office response to the 22nd of September stated, amongst other things, that contracts and Post Office investigations were outside of Second Sight's remit. Despite your agreement that the mediation scheme was to be available to all sub-postmasters whose cases had been identified by Second Sight as giving rise to concern, in recent months, Post Office has been objecting to around 90% of the cases going forward to mediation. Despite, paragraph 15, your agreement to fund the engagement of professional advisors to support sub-postmasters in all relevant stages of the process, the Post Office is attempting, in the absence of representation by those professional advisors, to have 90% of cases excluded from mediation. over the page. Despite your agreement that those who have pleaded guilty would be able to take advantage of the mediation scheme, Post Office has objected to cases going to mediation on the ground that the sub-postmasters pleaded guilty. You put forward these arguments in secret, and when MPs asked you in July how the mediation scheme was going, you pleaded in the interest of, quote, the integrity of the mediation scheme confidentially. Paragraph 18. Clearly the Post Office is aware of the Limitation Act point set out above. It has enough lawyers. The Post Office could allay any suspicion that this was a factor in the way it has been behaving by agreeing that it will not take any time-barred limitation point in resisting legal claims. Will you agree to this? I think the answer came back no.
It did.
From Paula Reynolds. You make the point in paragraph 20 you won't be standing at the next general election, and so some of the MPs have agreed that Kevin Jones would take over your role in the group. And you say at the end of paragraph 20, in any event, I couldn't continue negotiating with you because I've lost faith in the Post Office Board's commitment to a fair resolution of this issue, and I shall be pursuing the need for justice in other ways. I think you made a press release on that day as well.
I think I did.
Poll 00101690. And under the heading MPs lose faith in Post Office mediation scheme, you're reported in the second paragraph as saying the scheme was set up to help our constituents seek redress and maintain the Post Office's good reputation. It's doing neither. It's ended up mired in legal wrangling, with the Post Office objecting to most of the cases, even going into the mediation that the scheme was designed to provide. I can no longer give it my support. I shall now be pursuing justice for sub-postmasters in other ways.
Yes.
And that letter, the conclusions of the letter that you wrote, and that part of the press release that I've read to you, mark the withdrawal on your side of the equation from MP's engagement with the Post Office and its mediation scheme.
Yes.
Can I turn to the termination of the scheme by the Post Office and look at page 137 of your witness statement? Page 137. You say that on the 10th of March 2015 you heard via a Post Office press release that the Post Office had sacked Second Sight and disbanded Sir Anthony Hooper's independent working group. You thought there was a strong risk that the Post Office would try to suppress the briefing report that we've just read. So you wrote a letter to Paula Reynolds making a Freedom of Information Act request. Is it right that they replied to the Freedom of Information Act request saying it was exempt from disclosure, but they were voluntarily going to give you a copy anyway?
Yes.
But why did you think that the Post Office would try to suppress the report?
I thought they'd tried to suppress so much else that I couldn't trust them to release that.
Thank you, that can come down. Now, although there was some desultory correspondence after this, I think the next major event, and for you personally it was a significant one, was the dissolution of Parliament on the 30th of March 2015 and your cessation on that day as an MP.
Yes.
After that time, is it fair to say that your role in the investigation of Horizon and the Post Office's conduct changed?
Yes, it is. I was no longer an MP, and I was just sort of getting involved where I could, but that wasn't in many areas because of the group litigation.
You were ennobled in October 2015.
Yes.
And I think maybe you're downplaying a little bit your involvement after that time. You address in the balance of your witness statement a range of issues that you did have involvement in the 8 years since then.
Yes.
They include, I'm just going to list them, the SWIFT review, paragraphs 277 to 279 of your witness statement, your involvement in and commentary on the group litigation, paragraphs 280 to 308, the emergence of the Clark advice, and what you did when the Clark advice did emerge in November 2020, and you've told us immediately, you told us earlier that immediately you wrote to Lord Callanan, you wrote to the Speaker, and you wrote to the Lord Speaker. And you give commentary on the governance of Post Office Limited, governance by the government in terms of its management and oversight of the company that it owns, and the approach that ought to be taken by government to a body which is said to enjoy an arm's length relationship with the government.
Yes.
And you address finally your position on the board of the Horizon Compensation Advisory Board.
Yes.
And its efforts to secure redress.
Yes.
I've galloped through those last topics, which cover a period of nearly 8 years, at some pace. Lord Arbuthnot, is there anything else that you wish to say at this point concerning what has been described as a national scandal?
I think that with the help of this inquiry, we are moving belatedly to the right place. And so I'd like to say thank you.
So from my perspective, they're the only questions that I have for Lord Arbuthnot. There are no questions from core participants.
Right. Well, first of all, Lord Arbuthnot, I assume that there may be persons in the room who would like to give you the same sort of appreciation that I precluded them from doing yesterday in the case of this debate. So I'm going to ask them to show similar restraint today, but that does not mean that I cannot thank you profusely for the efforts you have put in, and in particular, your support for this inquiry, because it should be known that you were one of the first people to engage with the non-statutory review, which was not welcomed by many people, but you thought it appropriate to give it what assistance you could. So throughout my involvement in this process, I have had nothing but help from you, for which I thank you very much.
Well, thank you.
So thank you. That's the end of Lord Arbuthnot's evidence. We're going to try something that we haven't done before, which is if I can ask for one of the ushers to escort Lord Arbuthnot from the room and switch remotely to Sir Anthony Hooper.
He's not far away, as I understand it.
I don't know whether that's true or not.
You don't know where he is, in other words.
No, partly because it's all Mr. Blake's area of responsibility.
Right.
If we can just keep everyone seated in the room for a moment, there's about a 5-minute turnaround to get the screen installed. But we're doing it this way because there's no point in taking our extended break now, having only sat for 35 minutes.
Sure.
Good afternoon, sir. Can you see and hear me?
Yes, I can.
Yes.
I should have said sir and sir. Thank you, sir. This afternoon's witness is Sir Anthony Hooper. You have granted Sir Anthony permission to appear remotely from outside of this country.
Yes, and I facetiously said to Mr. Beer that Sir Anthony was not too far away, when of course I meant the opposite. He's quite far away.
He is indeed. Thank you.
Good afternoon, Sir Anthony. I'm the usher and I'm going to take you through the affirmation. Can you hear me okay?
I can.
Thank you. Please can you repeat after me? I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you.
Thank you very much, Sir Anthony. You should have in front of you on a screen or beside you a witness statement that has the unique reference number WITN 004300100. That is dated the 8th of March of this year, is that correct?
Yes, I have it before me.
Thank you very much. Could I ask you to turn to the 5th page where there is a statement of truth?
Yes,
Can you confirm that that is your signature?
yes,
And can you also confirm that that statement is true to the best of your knowledge and belief?
yes. Subject to 2 small corrections.
Thank you very much. Shall we make those corrections now? Where are the corrections in your statement?
Paragraph 7.
Yes.
In the 3rd line from the bottom, I wrote the figure 25. Since I wrote that statement, I've seen evidence which suggests that the figure should be 15.
Thank you very much.
In the last sentence, I say that I thought that none of the mediations had been successful. That is true. That is what I thought. But I have again seen recently documentary evidence which suggests that some had been successful. If so, I knew nothing about it.
Thank you very much. That statement will be published on the inquiry's website in due course and forms part of the inquiry's evidence. I'm going to ask you some supplementary questions this afternoon. You'll be well known to the lawyers in this room as a former Court of Appeal judge. You also sat as part of that role in the Court of Appeal Criminal Division. Is that correct?
Yes, for 7 or 8 years.
And
Well, for the whole of my career as a High Court judge and as a Court of Appeal judge.
Thank you. You were a High Court judge before you moved to the Court of Appeal, hearing both criminal and civil proceedings. Is that correct?
Yes,
And before that, you were a practicing barrister.
yes,
You retired from the bench in 2012 after nearly 20 years on the bench.
yes,
And now, amongst other things, you are the Deputy Chairman of the Ethics Council of Ukraine.
I am.
I'm going to begin by looking at a document that predates your appointment. Can we please look at poll 001588062, please? This is an email chain of the 6th of September 2013. And if we scroll down to the bottom of this page, we have an email exchange between Paula Venables and the company secretary, Alwyn Lyons. And we see there in the 3rd paragraph, it says, Kay Linnell suggested Anthony Hooper. He does know and is interested in being considered, although we do not know how much he would cost. Do you recall being proposed for the role that you subsequently took up by Kay Linnell of the Justice for the Sub-Postmasters Alliance?
Yes.
And do you recall how it is that you came to be proposed in that way?
I think I remember that Kay Linnell and I were on a professional body together, and I think we discussed it.
Thank you very much. And if we scroll up to the top, we have the response from Paula Vanells. And she says, really helpful. From what I've heard about Hooper, he sounds a good prospect, especially in view of who nominated him, provided we can be reassured that he will be even-handed because of that nomination provenance. If we look at the bottom email, please, if we could scroll down to the bottom of the page and over to the next page. We're here in 6th of September 2013. Over the page, please. There's one other paragraph that I'd like to draw to your attention, and that's the penultimate paragraph. Alwyn Lyon says to Paula Vanells, I know Susan, I think that's Susan Crichton, the General Counsel, thinks we've made a reasonable start, but that the wrong chair in the eyes of the JFSA, or JA must be James Arbuthnot, would take us backwards. And if we're going to transition Second Sight out of the equation, a chair who is strong and will take a decision based on facts, whether it will be in Poll's favour or not, will be a great asset. Just looking at that paragraph, were you aware when you started or when you were approached for the position about the thinking regarding Second Sight and the possibility that they might be transitioned out of the equation?
Not at all.
Would that in any way have affected the approach that you took to the role?
Well, it would have made the whole mediation process undoable, if I can use that word.
And why was that?
Well, they were a central part of the process.
Thank you. I'm going to move on to the terms of reference for the working group that you chaired. Can we look at poll 000222307, please? Thank you. So these are the terms of reference for the working group. Very briefly, can you just introduce the working group to the inquiry and just tell us what its purpose was?
Well, the background, of course, was the Second Sight report and earlier investigations. And if you look not at this document, but the other document which emanated from the Post Office, they were saying that they believed the Horizon system to be robust, but they were prepared to hear from, through this scheme, from sub-postmasters who took the view that it was not robust. It had serious failings. So it was a scheme designed to see whether or not the complaints from many post SPMs about the workings of Horizon were substantiated or not.
And how would that relate to, for example, mediation?
Well, I think that was the second part of it, is that I think the Post Office said, at least, that they wish to settle, or might wish to settle, some of the claims. So having gone through the procedure of the scheme, then there was an opportunity to mediate. I mean, if I can deal with it very, very briefly, we had about 150 applications. The applicants completed what was called a case questionnaire. That was looked at by Second Sight to see whether or not it contained sufficient information for an investigation, and that sometimes was sent back. That was often prepared by legal advisors who received some funding for that from the Post Office. If Second Sight were happy with the case questionnaire, we admitted them into the scheme. That was followed by the Post Office carrying out an investigation and producing a report. That report then went to us and to me and to the members, but to Second Sight. And Second Sight then prepared what was ultimately to be called a CRR, a case final, the case report. I can deal with the problems later, but that was the scheme. and then there would be a decision as to whether to mediate. The second side would give its view as to whether this was suitable for mediation, and then there would be a vote on it. And there were only two members of the scheme, namely the Post Office and the GFSA, in the form of Mr. Alan Bates. And so if the two of them couldn't agree, I had the deciding vote. But and we can look at that if you wish to do so, the whole problem of the mediation.
That's a very helpful introduction, and in light of that, we can skip through this terms of reference quite quickly. We have on our screens at the moment paragraphs 1 and 2, which sets out the scope and the members. If we scroll down the page, please, we have the objectives of the overall scheme. And then over the page, we have the role of the working group. At the bottom, we have you named as the independent chair. And then over the page, please, as you've just said, paragraph 7 sets out the decision-making process where members shall attempt to agree all decisions unanimously, but if a decision can't be reached, then it goes to a vote, and you had the casting vote in the event of disagreement. There's one paragraph that I would like to ask you about in respect of the terms of reference, and that's paragraph 2.4, which appears on the first page. It says at 2.4, in conducting working group business, Post Office may act in a manner that promotes its own interests. Likewise, JFSA may act in a manner that promotes the interests of applicants. Are you able to assist us with how you understood that provision?
I don't think I ever did understand it.
Did you understand the process to be an adversarial process, a cooperative process, or something else, in theory?
In theory, a cooperative process.
So paragraph 2.4 wasn't intended to set up some sort of adversarial process with each side pursuing their own interests?
No. I can't. It may have been explained to me at some stage why it was there, but I have no recollection now why it was there. And reading it, it doesn't make much sense to me. It's pretty obvious that the Post Office are going to look after its own interests, and the JFSA would do likewise.
We started today in September 2013 when your name was first mentioned. These terms of reference, we'll see, were finalised in March 2014. In between your appointment and the finalisation of these terms of reference, what was your initial work? What did that involve?
I don't think my work ever changed. I didn't know that I had forgotten that these were much later, but the way I ran the scheme as the chairman was exactly as I have described, and we started working as soon as we got going in October 2013, November.
Thank you very much. I'm going to take you to an email exchange in January 2014, so relatively early on in the scheme. Can we look at poll 00301-427, please? This is a discussion between lawyers at Cartwright King and Bond Dickinson. Could we please start by looking at page 4 and over to 5. It's the 16th of January 2014. This is a discussion between Harry Bowyer at Cartwright King and Andrew Parsons at Bond Dickinson, and they're referring to various case studies. If we scroll down the page, we can see the beginning of the chain actually starts with an email between Andrew Parsons and Martin Smith. Sorry, thank you very much. And it seems as though they're preparing case summaries for you already in January 2014. What was the purpose of those case summaries?
I think these are quite outside the scheme, if I'm right in remembering. And please, I remind you that this happened a long time ago. As I remember, there were about 4 cases in which the which were had gone past the charge stage and were to go to trial. And I obviously was concerned, not really in my position as a chairman, but simply as someone who wanted to make sure that there were no wrongful convictions. So I think I asked to look at the case summary, and I think I suggested that I would hope that these 4 cases would be dropped. That's my memory.
Thank you very much. Could we scroll up, please? And that is consistent with this email that's currently on screen, where Andrew Parsons